Welcome to the deep dive. We focus on cutting through the noise, especially, when you're trying to navigate the really complex world of immigration policy. It's always changing. Just imagine, maybe you've waited years, maybe even decades, hoping to reunite with family via a green card, and then boom, the rules shift right when you thought you were close. Well, that's become a reality for a lot of families starting August 1, 2025. Today, we're doing a deep dive into probably the biggest shakeup in family-based immigration we've seen in a while. It's a critical new policy guidance from U.S. Citizenship and Immigration Services, USCIS, and it kicks in August 1st, 2025. This isn't just some small adjustment, it's pretty comprehensive. It's really designed to tighten up the vetting for family-based green card applicants. So our mission today, unpack what this all means if you're in that process or maybe helping someone who is. We want to give you clarity, some practical insights, hopefully without drowning you in legal jargon. Think of this as your shortcut to understanding what's happening. Okay, so let's get into it. What exactly has USCIS done with this new policy guidance?
And importantly, where can people actually find these changes if they want to see the official text?
Right. So the core of it is this new comprehensive policy guidance. Like you said, officially effective August 1st, 2025. You'll find the details in the updated USCIS policy manual. Specifically, it's Volume 6, Part B. The main aim here seems to be standardizing and, frankly, significantly tightening up the adjudication process.
Adjudication, that's just how they review and decide on the petitions, right?
Exactly, how they make the decisions. This applies specifically to those family-based immigrant visa petitions filed by U.S. citizens and lawful permanent residents. It's really a push towards more consistency, more rigor.
It was less about a single new rule and more like a whole new operating manual for the officers making these decisions. What's the real significance of rolling everything into this new manual, and what specific changes will immediately stand out?
Yeah, that's a key point. The impact is pretty profound. This single unified manual replaces what used to be, well, kind of the old Bible for immigration officers, the Adjudicator's Field Manual, the AFM, plus it replaces various other policy memos that were scattered around. So think of it like USCIS consolidating everything, closing maybe hundreds of old binders into one stricter definitive guide.
Okay.
And this means it's not just tidying up, it signals a more rigid application of the rules across the board, potentially less room for, let's say, individual officer discretion. As for the specific new elements, a few things really jump out. First, it pulls together and restates the general eligibility criteria, the filing requirements, documentation needed for the Form I-130.
That's the main form for sponsoring family.
That's the one. The foundational petition where a citizen or green card holder says, hey, this is my relative, I want to sponsor them. Now, all those instructions, which used to be a bit fragmented, are in one place. In theory, that could be clear, but it also means the rules might be applied much more strictly, less wiggle room.
So even just filing that first petition is going to get a closer look. Sounds like they want applications to be completely airtight right from the start.
Absolutely. And that leads right into the second point, which is maybe the most significant change for many people. Officers now have clearer, much more explicit authority to require interviews.
The interview.
Yes. And the stated reason is specifically to verify the authenticity of the family relationship being claimed. So if you're sponsoring or being sponsored, you should probably expect that an interview might just become a more standard part of the process, not just for cases that look suspicious.
That is a really big shift. Are we talking about tougher questions in the interview, or just that more people will have an interview?
It could well be both, actually. It's not just that the threshold for triggering an interview might be lower, but the guidance gives officers clearer authority to really dig into the details during that interview.
Dig into what specifically?
The nature of the relationship, financial ties, maybe even the personal histories of the people involved. Imagine having to recount details, shared experiences, maybe under some pretty intense scrutiny by an officer whose job is now explicitly defined as verifying authenticity. It demands a whole new level of preparation. And the third key point, the policy allows USCIS to issue a notice to appear, an NTA, if the beneficiary, the person being sponsored, is found to be otherwise removable.
Okay, what does otherwise removable mean in practice?
It highlights a really crucial point. Just getting your I-130 petition approved doesn't automatically mean you get a green card or are safe from deportation. Otherwise removable means If there's any other reason why that person could be deported, maybe they overstayed a previous visa, have a past criminal issue, even minor, or maybe there are inaccuracies in past applications. Even if the current family petition is perfectly fine and gets approved, USCIS could still initiate removal proceedings based on those other grounds.
Wow, okay. So you could do everything right on the I-130, submit all the proof, have a genuine relationship, but something from years ago, maybe something you thought was minor, could suddenly derail everything. That really ups the stakes.
It absolutely does. It reinforces a fundamental point that maybe some applicants don't fully grasp. The I-130 approval is just one step, one hurdle. It's definitely not the finish line. And USCIS is making that much more explicit now.
This really feels like a major recalibration. So why now? What's the thinking behind USCIS bringing in these stricter measures at this point?
Well, connecting it to the bigger picture, USCIS has been quite open about their stated goal, preserving the integrity of the family-based immigration system. Historically, there have been concerns about certain types of fraud, maybe fabricated relationships, misrepresenting income or financial support, things like that. This guidance seems aimed not just at catching outright fraud, but also ensuring rules are applied consistently to sort of close potential loopholes and create a more predictable, if stricter, process. It's framed as bolstering public trust in these legal pathways.
Okay, so closing gaps, standardization, curbing potential abuse. Makes sense from their perspective. But let's bring it back to the applicants. People already in the process are about to start. What does this actually mean for their specific case? This is where it gets real for a lot of folks.
Yes, this is absolutely critical. The guidance applies to all family-based I-130s filed on or after August 1st, 2025. But, and this is the really important part for many, it also applies to petitions that were already under review before that date.
Wait, really? So even if you filed, say, last year, these new, potentially tougher standards could still be applied to your case?
That's correct. If your case hasn't been decided by August 1st, it falls under this new guidance. So people who thought they filed under the old rules might find themselves facing this enhanced scrutiny. You need to be prepared for that possibility.
That's huge. People might have prepared based on one set of expectations, and now the goalposts have shifted mid-game.
Yeah.
What's the likely practical impact? Does it mean lower approval rates or just longer waits?
The most immediate practical impact is probably that increased likelihood of an interview. Even if your relationship is completely genuine, you've submitted solid proof, officers will be applying these stricter criteria, which means an interview is just far more likely than it might have been previously. And naturally, more interviews mean more steps, which will almost certainly add to processing times for many. The idea is to catch discrepancies that maybe aren't obvious just from the paperwork.
Okay, so with this new focus on interviews, what are some common pitfalls people should absolutely avoid when they're preparing for or actually attending one of these potentially make-or-break interviews?
I think the biggest mistake is assuming the documents alone are enough. You really need to be able to talk about your relationship clearly and consistently. How you met, important dates, shared experiences, finances, even just day-to-day life stuff. It's crucial to review everything you submitted beforehand. Any inconsistencies, even if they seem small to you, could now be a red flag for the officer. Transparency, consistency, those are key. And that third point about potential removal proceedings, it really bears repeating. Even if your I-130 petition gets the green light, the beneficiary might still face removal if they're found ineligible later on. This often comes up during the adjustment of status phase, which is how someone already inside the U.S. gets their green card without leaving. This new guidance explicitly warns that even with an approved I-130, that adjustment isn't automatic if some other ineligibility pops up later.
So the message is loud and clear. I-130 approval is necessary but not sufficient. It's not the end of the story. Given that, what kind of due diligence should applicants be doing now to make sure they don't run into unexpected trouble like removal proceedings down the line?
They really need to ensure their entire immigration history is clean and accurately represented. Every prior visa application, every entry into the U.S. Was there ever an overstay, even a short one? Any kind of criminal issue, even if it seemed minor or was dismissed, a misunderstanding about the terms of a previous visa, any of that could potentially resurface now. Honestly, consulting with a good immigration lawyer to review your whole record before you even start this process seems more important than ever, even for cases that look simple on the surface. It's about identifying and addressing potential problems proactively.
Let's zoom out again for a second. It's worth remembering just how significant family-based immigration is overall, right? Why do these kinds of updates carry so much weight system-wide? This isn't some niche category.
Not at all. It's a massive part of the U.S. immigration landscape. Family-based visas make up a huge chunk, around 226,000 of the immigrant visas issued each year under U.S. law. Now, there are per-country limits, usually around 7% per country. That might sound equitable, but for countries with enormous demand, like India, China, Mexico, the Philippines, that 7% cap creates enormous backlogs.
Right.
We're talking waits that can literally span decades. It turns applying into a generational waiting game for some families. So the system is already under immense pressure, which also makes it, unfortunately, a target for fraud sometimes and definitely prone to long delays.
And speaking of that pressure, those delays we keep hearing about, these green card bottlenecks is impacting Indian nationals. I remember seeing the August 2025 visa bulletin.
Oh.
It showed only tiny movement for Indians in the employment lines, and the family-based states, which we're focused on today, were pretty much stuck. So this new guidance, layering more scrutiny on top, it's definitely going to interact with those existing backlogs, isn't it? Potentially making a tough situation even more complex.
It almost certainly will, yes. More scrutiny, more interviews that takes officer time, which could slow down processing overall, potentially adding to those already lengthy waits, especially in backlogged categories.
Okay, so navigating this new landscape really requires being proactive. Let's distill it down. What are the absolute key practical takeaways? The concrete steps someone should consider if they're sponsoring family or being sponsored right now. What should they do differently starting today?
The number one thing is preparation, transparency, and consistency. You absolutely have to prepare your documents with total transparency. Assume everything will be checked. Officers are now explicitly guided to expect deeper documentation, and like we've stressed, they're more likely to call you in for an interview. Don't leave anything ambiguous. Assume scrutiny. Second, genuinely expect you might have an in-person interview. It's not just for tricky cases anymore. Even what seems like a straightforward petition could now flag for enhanced review under these guidelines. So be ready to talk through your relationship details, have your supporting documents organized, even if you already sent copies. Third, really internalize that the I-130 petition approval is not the final step. It's just one stage. Removal proceedings can still be initiated later if other issues pop up during the green card application phase itself. Your whole immigration history matters. And finally, always keep tracking the priority dates in the monthly visa bulletin. This is absolutely vital, especially for applicants from high-demand countries like India who face those incredible delays. Knowing where you stand in the queue is crucial for planning, managing expectations.
That's a lot to take in. If someone listening is feeling really overwhelmed by all these changes, the uncertainty, what's the single best piece of advice you'd offer them right now?
Honestly, get qualified legal help. With this increased scrutiny, this is probably not the time for a do-it-yourself approach, even if your case seems simple. An experienced immigration attorney can really help you understand how these new rules apply to your specific situation, make sure your application is as strong and transparent as possible, and prepare you thoroughly for that potential interview. It's an investment, but it could significantly improve your chances. Proactive steps and professional guidance are really key here.
Okay, so to wrap it up, in summary, this August 2025 USCIS policy update really signals a deliberate, pretty significant shift.
Yeah.
It's moving towards greater enforcement, more uniform decision-making on these family-based green card petitions. And while the stated goal is curbing abuse, the practical effect for applicants and sponsors is definitely more scrutiny, the potential for delays, and a need for much greater procedural awareness and transparency.
Absolutely. Being well-informed, being thoroughly prepared, it's going to be more crucial than ever for anyone involved in these family-based processes. It really comes down to understanding this new landscape and adjusting your approach to make sure every step is taken carefully, transparently.
All the best, and we will meet again with another important matter again